Your Honor, you have been told that Section 94, subsection 1 is what Council is defining as normative derivative. That one is conception. In constitutional law, that provision does not qualify to be defined by that doctrine. The simple reading of the word normative means it relates to a norm, a rule, or a thing that should be. So if you were to argue, therefore, that Section 94, subsection 1 is to be constituted or to be construed as a normative derivative vis-a-vis the provision of Article 33, the question therefore posed to the court, therefore, in determining the norm in Section 93 would be, in normal circumstances, how would court regard such a statement captioned by the charge sheet? What norm is arising or accruing from the particulars of that charge? And must that norm conform to the provision of Section 7 of the 6th schedule? Again, simple reading of derivative means which can refer to something
Absolutely.
that is
And that means
derived or
clarity and
taken
accuracy
from
are
something
key.
else.
Do you want it made more punchy for a general?
It's about, that is to say, Section 94, subsection 1. If you were to juxtapose it to the normative derivative doctrine, vis-a-vis the provision of Article 24, cannot then be said to have accrued or arisen from the provision of Article 33. And that is why Council misses the point. Of course, deliberately so, because he does not want to appreciate the fact that Section 7 of the 6th schedule was enacted so that it can assist the court where an amendment has not been initiated by the relevant authority. I concede it's only Parliament that can legislate. Yes, that I concede. But in the absence of a legislation, what is the import of Section 7 of the 6th schedule? And what is the scope of the application of Section 7 of the 6th schedule? If the scope is not such, the scope of application is not such as this one. The reason why the people of Kenya enacted Section 7 of the 6th schedule, they were alive to the fact that not all laws that may suffer amendments or repeals upon the enactment of the new constitution. And therefore they created an avenue for a magistrate or a judge to have the flexibility of dealing with a situation as and when it arises. Of course, my learned friend would want to argue, on the contrary, that it calls you, it limits you and makes you rigid to the interpretation. That is not the expectation. He has addressed you on the question of the repeal. If, even when a repeal has not accrued of a section that is not in conformity with the Constitution, the obligation of the court faced with such a challenge is to make sure that that section does not defeat the purpose for which the Constitution was enacted. And then where do you get that purpose? You get that purpose under Article 10. for the benefit of my learned friend, who seldom practices constitutional law, Article 10 says, the national values and principles of governance in this article binds all state organs, state officers, public officers, and all persons whenever any of them applies or interprets the Constitution. That is not what we're inviting you to. Enact, applies or interprets the law. That is what we're inviting you to. This law, Section 19, Section 94, subsection 1. And at this juncture, Your Honor, you might want to seek the aid of the interpretation, the tools of statutory interpretation. And one of the tools I suggest that you apply in these circumstances is the golden rule.
Sorry, Your Honor, I hope we are not opening new areas of arguments because ours is closed. So counsel should just stick to what came up and the law so that we are not able to require.
He addressed you on the applicability of Article 10, Your Honor, and I have simply dealt with the question of Article 10. I invite you to apply the tool of the golden rule. In 1930, when this section was being enacted, what was most relevant was the mischief rule that Parliament, as at that time, wanted to address. And this case is the Parliament of the United Kingdom. Granted that this country was a protectorate as at then, and Her Majesty government wanted to guard, control, and subjugate the people of Kenya.
Your Honor, seriously.
Okay, I'll abandon that, but I know the court has noted. Now that we have the new constitution, so that you may not resort into the absurdity that the DPP is inviting you to, you must apply the tool that enhances the enjoyment of a right other than to limit it. And that you're being invited by Article 19, 20, and 21. To argue that Section 8 of the Magistrate Code limits you, again, would be to miss the point. There's no possibility that the Constitution can give you under Article 10, which provides, again about these values, and I want to just mention the value of human rights. That when seated there, Your Honor, you are bound by the values of human rights. And where do you get these values from? The Bill of Rights. So are you then supposed to apply the Bill of Rights selectively, exclusively, and in a limited manner? If you're then being invited that the only jurisdiction is under Section 8, subsection 2, then how are those rights contemplated? They are capable of being denied, violated, threatened, or infringed. By the deliberate use of the word threat in the section, threat, violation, denial, or infringement invites you to holistically analyze the entire concept of human rights. It does therefore not limit you under Section 8, subsection 2. Otherwise, how can the Constitution give you and then a legislation take it away from you? Then when interpreting that Section 8, again, you must interpret it in a manner that advances the enjoyment of that right, other than limiting it. Again, that is again on the doctrine of the law, that you expound the law in a manner that facilitates the achievement of that objective. I will again address you on Article 50, clause 2, paragraph B. And this, I'll leave it at this and then invite Mr. Kihara. Because this article, Your Honor, tells you that when a subject such as honorable member is brought before you, must be informed of the charges with sufficient details to answer. So the DPP does not just have the liberty of crafting anything and anything goes. That as long as you are here, the only obligation is to answer.
Your Honor, this argument was made by counsel when they were making their arguments. What we understand, let me finish, sir. Let us just have courtesy. What we understand as a response, just sit, I'm finishing.
Council, just sit down.
Yeah.
You know that you don't have a place to sit.
No, we don't. We are pleading that in response, so that we don't regurgitate, we just issues that have arisen.
Okay,
Legal issues.
I'll abandon that argument. I'll take that objection. So that, Your Honor, I'll then invite my friend to proceed and.
So, Mr. Njiru,
Yes, sir.
don't you think if you urge me, as you have done, in view of that section 7 of the 6th section,
Yes.
do you think I'll be cited for judicial overreach?
No.
It will be a classic case of judicial overreach.
There is no judicial overreach because if I was to read, and again for the benefit of my learned friend who seldom refers to it.
Sorry, this second time I'm not taking it. I am a master's holder in constitutional law. It's not. I am an advanced master's holder in constitutional law. It's not. So you should not throw those shades. I am extremely intelligent and brilliant and learned. You should not throw the shades.
It's one thing to hold a master's and another.
Sorry, yeah, I'm not on trial, Your Honor. I'm asking you to just respect me because I am not. No. Yes, this is the second time counsel is attacking me that I seldom practice. I am asking him to respect me because he's my friend.
Okay.
That's not my practice.
Yes, Your Honor.
So which has demonstrated his stellar credentials.
Yes.
Let's not challenge.
And we are not surprised by those credentials, but surprised by the inability to apply the same.
I am. Now this is causing us damage here. I am not the kind of person to be intimidated by people like this and Ndegwa. So this court should just direct him that he respects the court if he doesn't want to respect me, and if he doesn't want me to lose my respect for him today. Because I take my education seriously, having risen from Islam, that I can't allow someone to just make shades. So please, just respect me.
Let's not descend from that. I was actually about to praise the council for their appropriateness and their propriety. But now I think we almost descended from Let's just maintain our code and decorum. You already wound up. I was just expressing that perspective.
Yes, Your Honor. There was no judicial overreach, because the philosophy behind the enactment of Section 7 was in the mind of the drafters of the Constitution that there exist laws and there was need and the necessity to save those laws so that they may not all be considered to be inconsistent with the Constitution by virtue of Article 2 of the Constitution. And that is why, Your Honor, Section 7 says all laws in force immediately before the effective date continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. So this is an invitation to any judicial officer who seeks to adjudicate over a dispute. Additionally, Your Honor, this is also in respect to any other state organ that is invited to apply laws. For example, the procurement laws that were enforced before then, or perhaps the marine laws that were enforced before then, or any other law. So there will be no judicial overreach, Your Honor, if you are then to apply, because that is a constitutional invitation that you cannot avoid. Most of that.
Thank you.
The chairman has 2 seconds, just 2 minutes.
Your Honor, I don't know whether this would be an interruption of the proceedings.
Mr. Whitty has a habit of always rising when I rise. If I stand, I can submit when he's standing. I don't have a problem. But let me make the submission.
Your Honor, I was just going to make a small request. I am not your enemy, sir. I was going to make a request so that before they are done, we let them finish. I just want to mention an authority. I'm not arguing. Just bring it to your attention if you allow me to read a paragraph so that as he responds, they also tackle.
No, we are beyond that.
I am allowed to make an application to reopen.
He has already closed his
So,
case.
Yes.
I'll address that. Let's just finish with that.
Okay, that's fine.
Let's just finish. They're responding to what you raised.
He cannot be allowed to be sitting in
I
the
think,
group.
I think the court has directed. The court has directed.
Yes.
Yeah, Jonas, very quickly, very quickly. There is a suggestion that we are inviting you to a mini trial prior to plea. In many words, that's how we call it. We are not asking you to evaluate any evidence. We are only asking you to look at the content of the charge sheet in terms of the wording, and look at the relevant section of the law that is said to be based, and make a judicial determination in accordance with section 89, subsection 5 of the CPC. Also, section 104 of the CPC. That is all what we are asking for. When prosecution brings a case before you, a charge sheet that is before you, and a suspect before you, it is in exercise of the ODPP's power under Article 157. We had talked about this. And as I had said earlier, this power must not be abused. Indeed, and Mr. Whitty knows this very well, that what sub-article 11 says is that that power of the DPP, in exercising the powers conferred under this article, the DPP shall have regard to the public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process. So, when a charge sheet is brought before you, that is clearly an abuse of the process, Your Honor, that is a charge sheet that you should reject, and the court gives you, the law gives you that power. Lastly, our learned senior who is not with us today is Mr. Kibe Mungai, told us in another setup, another court setup, that there is a reason why that the new constitution, the bar on this side, the defense, the prosecution, and the bench was made to be advocates. We no longer have police officers on that side, advocates, and then there used to be district magistrates on that side. Those days. Now we have advocates. So that when materials are brought before the courts, the level at which we interrogate them is not the basic level. We should present before the court and be heard before the court, and the court applies its mind, its legal mind, to assess a situation so that we prevent and avoid abuse of process. How do I say this? There was a suggestion by my learned friend that when a charge sheet is brought before you, your role is to tell the accused person plead guilty or not guilty, and then evidence will come to prove or fail to prove. That is not what the Constitution envisages. It envisaged a situation whereby